Hello, thank you for watching this video. Maybe you are on my website for my law firm, the Law Office of Ryan J. Casson, or perhaps you're on my YouTube channel, A State of Affairs. I just wanted to let you all get to know me a little bit and talk about my estate planning philosophy very briefly. What would it be like to work with me if this video is able to convey that in just a couple minutes? So folks, at the end of the estate planning process, and you get a binder that's kind of like this. It may or may not look like this in estate planning portfolio. What's in there and why do we have that? A couple concepts that I enjoy discussing with my client are flexibility, what we might call post-mortem flexibility after you pass away. We want your loved ones and we want the professional team working on behalf of your beneficiaries to have that post-mortem flexibility to navigate changed circumstances and changes in tax laws. Sometimes that means we're incorporating certain guardian angel or superhero provisions, which I like to call the trust protector. That's a very common concept, but I like to call the trust protector role a superhero role or a guardian angel role. So that type of article or section or a part of the trust really works to afford a flexibility to the successor trustee and to the beneficiaries during your incapacity generally and after you pass away. So there are other provisions we can incorporate in the trust that help manage income tax and just to, frankly, render the beneficiaries better able to have some flexibility when they take income distributions or whatever the terms of the trust say. Sometimes the trust will dictate that a beneficiary inherits outright and free of trust. When a beneficiary inherits outright and free of trust, their portion of the trust is, basically shut down. It's done. It's over. There's no ongoing annual administration that happens for that beneficiary. It's in their name. It's in their bank account. And what does that mean? And this is the second point I want to make regarding flexibility. It's not necessarily flexibility, but it's related to flexibility, creditor protection. Once that beneficiary receives a distribution from their trust share, such as outright and free of trust, it's totally exposed to that beneficiary's creditors. So I enjoy talking to my clients about potential options we have at our fingertips to try to maximize creditor protection for the beneficiaries. And oftentimes, one of the best ways to maximize creditor protection for beneficiaries is to allow the beneficiary's inheritance in the trust to stay in trust. A mandatory, ongoing subtrust. So your main trust document, the big trust, breaks down and it spins off certain subtrusts. 50% for child number one, 50% for child number two, for example. And those trusts continue year after year, oftentimes with an independent trustee. Potentially the beneficiary could be their own trustee, but to really maximize that creditor protection, we would have a independent trustee such as another attorney, a trust company, a private professional fiduciary, a trusted friend, for instance, who would have total sole and absolute discretion in their own discretion to distribute or not distribute property to the beneficiary. So an independent trustee with pure, absolute, sole discretion to make distributions, including no distributions at all, that, believe it or not, really affords some excellent excellent creditor protection for that beneficiary. So that beneficiary would have no right to withdraw, let's say 50% when they're 30 years old, and then the remaining 50% when they're 35. If the trust did say that, that portion would be exposed and available to that beneficiary's creditors. So again, in summary, here at my office, I really enjoy and I like to recommend to my clients a revocable living trust and an irrevocable trust if necessary. And sometimes we use South Dakota law for that, and I am licensed in South Dakota. And I am able to prepare South Dakota asset protection trusts. But folks, for a more modest estate, your revocable living trust, which becomes irrevocable at the moment you pass away if you're one person, and generally it's upon the passing of both spouses or both parents, that is when the trust would become irrevocable if there's two of you as a married couple. But even then, we can kind of get into the weeds and talk about, well, what happens when the first spouse passes away? What happens to that spouse's portion of the trust? That is a whole nother conversation for another video. But again, in summary, I recommend flexibility, whether that's incorporating trust protector provisions or, powers of appointment as they're called, or a power to withdraw income over a certain amount or below a certain amount, to afford beneficiaries and your trustee flexibility to navigate whatever might be coming along that highway when the trustee's driving your car and looking at that roadmap, which is your revocable living trust, which at that point has become irrevocable. We want your trustee, we want that roadmap to point out, the detours that might be coming, the potential construction, and we never really know when that's going to hit. So flexibility and creditor protection are two things I love to talk to my clients about, in addition to the other ancillary estate planning concepts, of course, such as your power of attorney for finances and the medical power of attorney for healthcare decisions. And I would just point out as a final point, folks, the power of attorney, that agent that is authorized to act on your behalf under the power of attorney for finances, that agent has control over a non-trust property. So that's just a little point if you weren't quite clear on that. The trustee manages, in accordance with the terms of your trust, the trust property. But what if there's a brokerage account or a bank account, that is not titled to the trust? Well, the power of attorney would have authority over those types of assets to the extent authorized in the power of attorney. And sometimes your power of attorney person, the agent, is the same person designated in your trust as the successor trustee. It doesn't have to be, but oftentimes it is. So we can talk about these concepts, folks, if you were to reach out to me and hire me for your estate planning process. I hope to hear from you, and thank you so much for watching this video. I hope that it was helpful to let you get to know me a little bit about a couple concepts that are important to me, and by extension, I try to strive to make sure that you understand that they should be important to you as well. Again, flexibility and creditor protection. It's not as hard nor as complicated as you think. All right, have a great day.